Починаємо наш міжнародний тренінг з англійського контрактного права. Сьогодні і завтра ми попрацюємо. Ми з офісу Interlegal в Одесі. Мене звуть Артур Ніцевич, я партнер Interlegal. Поруч зі мною мій партнер Олексій Ремесло, який очолює практику англійського права у фірмі Interlegal. Сьогоднішній курс ми проводимо разом з Чорноморським інститутом морського та торговельного права Black Sea Shipping and International Law Institute і присвячуємо його актуальним питанням англійського контрактного права. Партнерами курсу виступають, і ми щиро дякуємо їм за підтримку, Європейська бізнес-асоціація, АПК «Інформ», Українська зернова асоціація, RDL Group, журнали та видавництва «Судоходство» та «Порти України». Для агротрейдерів та брокерів з шипінгу не секрет, що англійське право грає домінуючу роль у міжнародній торгівлі сировинними товарами. Це так навіть там, де сторони та вантажі, що продаються, що не мають фактичного зв'язку з Англією. Англійське право має багату історію прецедентного права, яке служить посібником для торгових компаній при продажу на умовах ФОП, СІФ та інше. Наш практичний курс «Англійське контрактне право» проводиться юридичною фірмою Interlegal щорічно. Це наш унікальний інтелектуальний продукт, який базується на нашому юридичному досвіду з 1995 році. І ми запрошуємо у якості експертів славних ключових гравців рынка. Я вынужден перехожу на русский язык, поскольку сегодня среди нашей аудитории у нас, кроме делегатов из Украины, есть делегаты из Молдовы и Казахстана, и поэтому мы вынуждены используем русский и английский язык как языки международного общения. У нас сегодня и завтра обеспечивается синхронный перевод. С русского на английский это будет завтра, а сегодня с английского языка на русский. У себя на панели вы видите внизу кнопку «Перевод», и там можете выбрать интересующую вас опцию. Значит, пару, наверное, еще технических таких вопросов. Работаем мы 2 дня. Я думаю, что мы где-то будем ориентироваться до 3 часов каждый день. Продолжительность и сегодня, и завтра. Естественно, что у нас презентации, мы зависим от спикера. Но мы также надеемся, что вы будете задавать вопросы. Вы можете накидывать вопросы в чат, либо в рубрику «Вопросы и ответы». Мы с Алексеем вместе будем это модерировать и адресовать нашим уважаемым спикерам. Ну, наверное, по техническим вопросам на главных я остановился. И я перехожу на английский язык, потому что сегодня у нас английский, можно сказать, английский день. У нас сегодня 2 спикера англоговорящих. И кому удобнее, повторяю, можете использовать опцию «Перевод» у вас на панели Zoom, если вы желаете слушать сегодняшние презентации в переводе на русский язык. So there will be 2 speakers today. The first one will be our good colleague, friend Richard Faint, who invests his time and efforts every year in educating Black Sea business to the grounds of English law. Richard is the originator of the Black Sea Institute of Shipping and International Trade Law. This was originally his idea, and we at Interlegal did support this idea and implement it into life and business. From time to time, we run on this on the educational platform different webinars dedicated to shipping and commodities trade law. Please check our website for details. I may announce that in May, in about a month, we are planning a new event which will be open, free access, and it will be dedicated to general average topic. So, interestingly to know that Richard has spent all his life at, let's say, at sea. First on the deck as a seaman, then in the office as a commodity trader, and finally in the office as an arbitrator. He got different qualifications, LLM from Southampton University, MBA from Shepperton University. He is an ex-arbitrator at GAFTA. He's a supporting member of the London Maritime Arbitrators Association. He's got good experience in FOSFA. So he's going to cover today, let's say, basic principles of English contract law without understanding them and knowing and reminding each other these basics. It is not possible to implement English contract law in our day-to-day business activity. And the second speaker is Jean-Paul de Zutter. Welcome on board as a speaker, Jean-Paul. Today, Jean-Paul will dedicate his presentation to late time and demurrage issues. It's a very interesting, hot, let's say, topic, eternal topic, and we have also a wonderful presentation from Jean-Paul. So the first speaker is Richard Faints. Dick, you can start, I think so.
Yes, we can start, and while Richard is connecting demonstration his screen, I just want to remind you that please ask your questions in the chat. We will follow them. Thank you. Richard, we are ready. Please switch on your demonstration.
Green button, yeah.
Yes, the green button.
Screen demonstration. Yes.
Okay, we now have it. Okay.
Yeah.
Well, thank you for
Richard, the floor is yours. We are ready to start.
Okay. Well, thank you for that wonderful introduction. And I do hope that the Black Sea Institute of Shipping and Trade Law goes from strength to strength. I think the Black Sea region needs it, certainly Ukraine. Good morning, everybody. Thank you for the invitation. Let's start. I have provided a fuller paper. What you're going to see on the screen is just the bullet points. You can download the paper from Interlegal later. So I've been asked to speak about English law and commercial contracts. I'm going to limit this to commodity and shipping contracts. The questions I'm normally asked are, why use a contract governed by English law? The second question that follows generally is, why are the contracts so complicated? An American legal scholar, Fred Rodel, came up with a very good description to cover this problem of complicated contracts. The whole law of contract is based on the idea that men in general cannot be trusted to keep their promises. And around this area of mutual distrust, the law lays down principles. So the intention behind this talk, commodity trading, all about trading, transporting cargoes from one place to another. We have a lot of ships involved, remarkably few working cargo vessels really to carry all the various commodities around the world. You are involved in this trade, and I hope to explain why we use English law, contracts, and settle disputes in London. Traders are international. To avoid dealing with different legal systems, international trading uses English law as an accepted or perhaps acceptable system. Traders use this because they can then trade with confidence. To do this, traders have joined together in something called trade associations. There are a great many trade associations for steel, for sugar, for cotton, many, and I mentioned just two that have their headquarters in London. GAFTA, the Grain and Feed Trade Association, now has over 1,900 members in 100 countries. These members include traders, brokers, superintendents, analysts, fumigators, arbitrators, and other professionals, all active in the trade. GAFTA can trace its roots back to 1878, when the London Corn Trade Association was established. Phosphor has over 1,200 members in nearly 90 countries. And as I say, a full copy of this paper with all the details can be downloaded. So we'll move on. GAFTA, which is the larger of the two, looks after and protects the interests of the grain and animal feeding stuffs industry in national and international affairs. Business done on GAFTA contracts amounts to over 80% of the world trade in cereals. Phosphor International was formed in 1971 from previous associations going all the way back to 1863. Membership, I put it here, 1,128 companies in 90 countries. Like GAFTA, it is a professional international contract issuing and arbitral body concerned exclusively with world trade in oilseeds, fats, and edible groundnuts. It's the leading association of its kind in these, well, both of these are the leading associations in their fields. Business done on FOFTA contracts amounts to 85% of world trade in these commodities. So GAFTA and Phosphor alone are concerned with many thousands of individual contracts and with an annual turnover of billions of US dollars. Along with other trade associations, they work with governments, non-government organizations, including the FAO, Food and Agricultural Association, organization. There are some details of their work within the FAO biannual reports. The grain business, our business, is big business, and the International Grain Council report, which you should all read, advises that volatility is expected in the short term. This was stated on the 20th of February, so it's a recent comment. The concrete benefits of using standard form contracts. The size of this business means that there are mountains of information out there. This business, the grain trade, the oilseed trade, generates many thousands of contracts taking place between people who do not share a common language and are operating under different legal systems. Because of this, you begin to see the value and benefit in belonging to a trade association and using their standard form contracts, which have been developed over the years by these associations. Imagine trying to trade internationally without some standardization of contract terms and languages. Without this approach, there would be many, many more disputes with lengthy and unnecessary disputes. Arbitration litigation comes with associated costs, not just in dollars, but in time loss and effort. By using a standard service provided by trade associations, commercial life is made easier. The standard form contracts, these are drawn up by the members to suit trade practices. They're drawn up through elected specialist formed members from different countries, ensuring a fair balance between buyers and sellers, from producers to end receivers. Contract committees in all trade associations are charged with regularly updating and amending as trade terms change or circumstances dictate. A standard form contract provides a large measure of safety for all concerned. Developing standard form contracts is an ongoing matter. It involves participation of all sectors of the trade. I would suggest that if you are not members of the trade association, it would be of benefit to you to become a member and to participate in the contract committees to have your say. Services to the trade, superintendents and analysts and lawyers and arbitrators. Many people are involved in trading, but it all comes down to a seller expecting to be paid for the goods he has shipped. The trade, of course, relies on services provided by superintendents, analysts, carriers, ship owners, banks, and insurance in preparing what is known as the shipping documents. In thinking of the shipping documents, it is often said that this business, trading, is the sale of documents rather than the sale of physical goods. We'll come back to that. So, in real terms, what does a seller have to do to ensure that he is promptly paid? He needs to understand what is required of each party, that is, the duties and obligations on each party, and the proper execution of agreed terms agreed in the contract. The basic, rather simple definition of a contract of sale: an agreement to sell and an agreement to buy on equal terms. It actually is that simple if each party performs their obligations towards the other party. Traders are not in the business of creating problems, but problems do occur. And this is when we have to examine what was agreed in the terms of the contract. Only when a problem occurs do traders need interlegal and Jean-Paul, and this usually follows a failure to perform the obligations agreed under the contract. The innocent party will look to the law to enforce his rights under the contract. So we need to discuss just what amounts to a contract under English law. How does a contract come into existence? This is a question which is often put to arbitrators. English law has the Sale of Goods Act 1979, which defines a contract at section 2.1 as, and I will read this out, a contract of sale is a I'll start again. A contract of sale of goods is a contract by which the seller transfers or agrees to transfer the property in goods to the buyer for a money consideration called the price. Be aware of section 2.5 and 2.6 as they make a distinction between future sales and actual sales. 2.5 reads, where under a contract of sale, the transfer of the property in the goods is to take place at a future time or subject to some condition later to be fulfilled, the contract is called an agreement to sell. 2.6, an agreement to sell becomes a sale when the time elapses or the conditions are fulfilled, subject to which the property in the goods is to be transferred. Okay, we'll continue this. Traders should know, how does an arbitration tribunal decide that there is a contract? As an arbitrator, I would look for three basic elements before I can accept and recognize that a contract has been created. We often see arguments. There is no contract. I did not agree. It's not in writing, whatever. So the arbitration tribunal begins by looking to see agreement. This is the first requisite. Parties must have reached agreement. Agreement is reached when one party makes an offer and the other party accepts that offer. Offer acceptance. We hear this quite often. Example, a seller offers to sell 10,000 tons Ukrainian barley, $10 a ton, FOB Odessa, shipment first half November. This will be taken as an expression of willingness to contract with the intent that it becomes binding on the seller as soon as it is accepted by the buyer to whom it is addressed. So I make an offer to sell 10,000 tons, FOB Odessa, shipment first half November. I address this offer to a particular buyer. This first bullet point is something which jurisdictions outside of the English system sometimes have problems with. English law recognizes that an offer to sell does not have to be in writing. Oral contracts are acceptable. It should be clear and made with the intent that it should be binding if accepted. So a telephone discussion, an offer and an acceptance can be taken to be a binding contract. Be careful here. Be careful and do not make a unilateral offer, that is, an offer to the world at large that could be accepted by anyone, anywhere. This is an example of a unilateral offer. Carlyle v. Carbolic Smoke Company. It's an old case, 1893. A medical firm advertised that its new drug, a carbolic smoke ball, literally something that you set fire to, would cure flu. And if it did not, the buyers would receive £100. A buyer did sue. And when sued, Carbolic argued that the advert was not to be taken as a legally binding offer. It was merely an invitation to treat, a mere puff or gimmick. However, the English Court of Appeal held that the advertisement was an offer, an intention to be bound could be inferred from the statement that the advertisers had deposited £1,000 in their bank, showing our sincerity. The wording of the offer was open to anybody. It was backed by a promise that they had deposited money to show that this offer was a valid one. The Court of Appeal accepted their argument. So we can say acceptance. Once an offer is accepted, it's taken as a final and unqualified expression of assent, agreement to the terms of that offer. Tribunals will look for objective manifestation by the buyer, the receiver of the offer, of intention to be bound by its terms. For there to be agreement, the offer must be accepted in accordance with its precise terms. Acceptance must exactly match the offer, and all terms must be accepted. No legal effect can be given until acceptance is communicated to the seller. Otherwise, it could cause hardship if the seller could be bound without knowing the offer has been accepted. If acceptance is instantaneous, email, it takes effect at the time and place of receipt. Be careful and take note that the seller, the person offering the sale, cannot stipulate that the buyer's silence amounts to acceptance. This argument comes up quite often in arbitrations. Silence is not acceptance. Counteroffer. A counteroffer can either be accepted or rejected. Where the seller offers to trade on its standard terms and the buyer purports to accept, but only on his own standard terms, that represents a counteroffer. Making a counteroffer is a rejection of the original offer. The original offer is considered to be dead. It can only be restored or accepted by agreement. It's important to distinguish a counteroffer from a mere request for further information regarding the original offer. The buyer may come back, excuse me, sorry about that. Excuse me in one moment. I thought. Hello? Sorry for that interruption. The counteroffer can be either accepted or rejected. Making a counteroffer has to be taken as a rejection of the original offer. That original offer is dead. It can only be restored by acceptance or by agreement. Sorry. 1 second. My apologies for that. It's important to distinguish a counteroffer from a mere request for further information. If a seller is offering to ship on a bulk carrier, a request to confirm whether the bulk carrier is geared or ungeared is a simple request for further information. a request to confirm the draft of a vessel, that's not a counteroffer, just a request for further information. An offer may be revoked. The seller can revoke his offer at any time before its acceptance, but revocation, taking away that offer, must be communicated to the buyer. Although revocation need not be communicated by the seller personally, it can be done through a broker. If there is no communication that the offer has been withdrawn, the revocation is not, it's ineffective, it's not effective. Once the offer has been accepted, the parties have an agreement. That is the basis for a contract. It is not sufficient in itself to create legal obligations. Why? We have to have consideration. This is important in English law. Under common law, a promise will not be binding as a contract unless supported by consideration. What do we mean by consideration? Consideration must be something of value given for a promise and is required in order to make the promise enforceable as a contract. Examples of consideration: payment by a buyer is obviously consideration for the seller's promise to deliver goods, and delivery of goods is consideration for the buyer's promise to pay. If I offer to sell you my house for $1, this is valid consideration. I'm not going to do it. If I offer to give you my house for nothing, there is no consideration, and this agreement could not be enforced. Be careful. An informal, gratuitous promise does not amount to a contract. Consideration must be sufficient, but it need not be adequate. A tribunal or court is not interested in adequacy of consideration, that's a fair price, but only with whether the consideration in question can be expressed in terms of economic worth. This sounds complicated, but it's not. An example of the worth or the value of consideration can be seen in the case of Chappell v. Nestle. Chappell was a seller of records, music. The records were sold with the consideration being payment of 1 shilling and sixpence, 15p in new money, and 3 chocolate wrappers. So in order to obtain the record, you paid the money and produced 3 chocolate wrappers. You then walked away with the record. The question for the court in this case was whether the chocolate wrappers formed part of the consideration. The court held that the chocolate wrappers were good consideration, even though Nestle simply threw them away. It follows from this that the wrappers would have been good consideration even if no sums had been paid. So consideration in English law, very important. Contractual intention, the final hurdle before we can say that a contract is binding. But even where agreement is supported by consideration, money, something of value, it is not binding as a contract if it is made without an intention to create legal relations. Parties must intend their agreement to be legally binding. In our world, in our trading world, there is a presumption that parties intend to create legal relations. The onus to defeat or rebut this presumption is a heavy one. It's difficult. That party would have to show that no legal effect was intended. An agreement made subject to contract, typically, agreements for the sale of land or a letter of comfort, is generally unenforceable. The words negate any contractual intention to be bound until formal contracts are exchanged. There are more details available from the full paper. Is there a contract? It's commonly the first question that arbitrators have to deal with. The most common argument made in defense is that there is no contract because, one, the contract was not signed. It does not have to be signed in English law. Second frequent defense is to claim that the person who made the deal did not have authority to do so. Generally, an English tribunal will find an implied authority for that person to make a binding contract. Thirdly, the respondent did not agree to English jurisdiction. And I'll say a bit more on this below. Lastly, no agreement to arbitrate in the contract. The simple answer to that is if you trade on trade association standard forms, they make reference to disputes being referred to arbitration in London. So by trading on standard form contracts, you are agreeing to disputes being referred to arbitration in London. The purpose of contract law is to enforce promises made. This refers back to the first comment I made about generally people distrusting the promises made by other people. The actual form of a contract is an open question. As said before, contracts can be informal, with an informal exchange of promises over a telephone considered legally binding and legally valid in the same way as a written contract. At a basic level, brokers issue a confirmation to both seller and buyer advising a trade has been done or completed. Often just an email, this confirmation sets out the date of the agreement, description of the cargo, quantity, specifications, load and or discharge port, shipping period, price and payment details. It could look like the example shown in the paper. I'm not going to waste time by putting it up here. Trade contracts and arbitrations. Both GAFTA and FOSFA, and to a lesser degree the LMAA, have committees that review every aspect of the trade, formed from members within the trade. As I've said before, GAFTA's International Contracts Policy Committee, to give it its full name, consider any amendments to a contract or propose new contracts. Contracts provide for different commodities covered by generic terms, grain and feed. Different trading terms are covered, CIF and FOB, and various variations of these. There is even a GAFTA charter party. Tally-qually contracts are where the buyers agree to accept the goods as they come, subject to them being shipped in good condition. Right terms are conditions or where the condition of the goods on arrival is guaranteed by the seller. It's important to stress trade contracts are drawn up by trade members to suit trade practices. As they change and develop, they may have to be changed. These contracts do not impose trade practices or methods on the trade. Trade contracts also set quality and condition parameters, sampling rules, GAFTA 124, plus superintendent schemes which set down a strict code of practice. We come back to the importance of certainty, and the old adage, my word is my bond, cannot be stressed enough in international trade. GAFTA, FOSFA also provide arbitration or dispute resolution services. These services were developed because trading companies do need certainty. By choosing English law and jurisdiction, they get certainty and are willing, in most cases, to be judged by their peers rather than the courts. So both associations have arbitration rules. For example, GAFTA form number 125. The arbitration clause being part of the standard form contracts, they are deemed to be part of the agreement contract between the parties. GAFTA arbitrators must be members of GAFTA who are or have been engaged in the trade for a minimum period of 10 years and are registered on the list of qualified arbitrators. So the question, why is arbitration used? Trading companies have historically tried to resolve their differences amicably rather than through the courts. Rules for the settlement by arbitration involved. Traders look to one of their peers, generally an experienced trader in another organization, for a quick resolution. Please remember that arbitration in England is private. Disputes are therefore resolved without news of that particular commercial problem being broadcast in the marketplace. Trading companies want speedy and cost-effective solutions. Attempts are made to keep a check on costs with rules that prevent lawyers from presenting cases in arbitration hearings unless both parties agree. You can see this in GAFTA 125 Rule 17. Where only one party is using lawyers, legal costs are not recoverable. Because traders will be buying and selling the cargo or trading on, there can be string arbitrations. And these rules are developed to cover this aspect. See GAFTA 125 Rule 7. So buyer A sells to B, that seller then sells on to C, and so on. These string rules, string arbitrations, are part and parcel of international trade. I'm often asked this question, arbitrators' qualifications, how are they obtained? Trade arbitrators generally drawn from ranks of trading companies. While it varies from trade association to trade association, most have open requirements. Anyone can become a trade arbitrator by satisfying set requirements. A person must be either an individual member of GAFTA or have permission of employers that are members. Candidates must also meet GAFTA continuing professional development program requirements by completing the grade 2 section of the CPDP, earn 75 CPD points, and successfully complete all the elements of the GAFTA trade diploma. The GAFTA process and interlocutory proceedings. These are similar to other trade associations. There's no set procedure, but appeals tend to be more formal than first-tier arbitrations. GAFTA have produced an A to Z of arbitration. This is a guide for users, but also aimed at lawyers. I say this because under drafting of submissions, it says the purpose of submissions is for each party to state and explain its case, with submissions being written in plain, clear language. Submissions are not pleadings, and formal or court rules of pleadings do not apply. I would suggest that most trade arbitrators would agree that many submissions are written as if they were being presented to a court. They do not have to be. They need to be written in plain and clear language. Orders for discovery or directions or peremptory orders are all explained in the A to Z. The majority of cases that come before first-tier arbitrators are dealt with on a documents-only basis. Arbitrators meet to discuss as and when required. When satisfied, the chairman of the tribunal advises the parties that submissions are closed and the tribunal is moving towards issuing its award. The validity of the arbitration process, it may be that one party does not wish to go along with that arbitration process. Some parties try for a court order claiming the matter should be dealt with in the High Court. If you are in this position, speak to Arthur and his team at Interlegal. The usual position would be that the court would not accept to deal with the case if there was an arbitration clause in the contract. This is known as the Scott v. Avery rule. It is a condition precedent to the enforcement of any rights under that contract that there will be an arbitration award. So if you have agreed to trade on a standard form contract, you have agreed to use that trade association arbitration process, and the courts generally will want to see that that arbitration process is complete before they will intervene. The enforcement of the arbitration award, generally covered by the New York Convention and the Geneva Convention. Most GAFTA-FOSFO awards are honored. It's one of the advantages of the system. From time to time, it can happen that a party will fail to honor an award, and the claimant will then resort to relying on these conventions to force the award through the court where the debtor resides. In such situations, called interlegal, or if you're in Belgium, called jambon. Conclusion. This has been a rush through English law on commodity contracts and arbitration. Interlegal can fill in any gaps. Please read my full paper. I can say that arbitration in London is an accepted part of trading life, and I believe that in general it works very well. I thank you for listening. I hope I have got my points across. Thank you.
Thank you, Richard. Thank you very much. Let's check the chat section. We have one question. I will try to translate to English. So if the contract stipulates that there should be the advance payment.
There should be
advance payment. Advance payment.
Oh, yes, yeah.
Yeah. But the buyer failed to make this payment. What can seller do? Can he hold the delivery, and can he claim some damages for that based on the English law?
Based on
quote-unquote translation, yeah.
Okay, based under English law, the first question here is the consideration. The buyer has made a promise to make an advance payment. Okay, that would be a promise of consideration. If that consideration is not met, then quite simply, no consideration equals no contract. The seller then would have to put his buyer on notice. You have failed to make the advance payment. You are in breach of your obligation under the contract. I will bring this contract to an end. And he can, if he, at this stage, I should imagine arrangements are already in hand, he can make an offer. If the advance payment is not received within 3 banking days, the contract will be at an end and I will claim damages.
Thank you, Richard. Thank you.
Okay, so there are a few questions. The next one is, what about using messengers? Because nowadays, like WhatsApp, like Telegram, other messages, modern technologies come into our life with every day more and more actively. And sometimes we see that no contracts are signed in paper. But what about the validity of correspondence in messengers? Are they binding? To what extent are they binding? How arbitrators treat correspondence in messengers?
Right. My first answer is to remind people that under English law, contracts do not have to be signed to be binding. So that brings in the next point, the intent of the parties. Yes, communication or the internet world is changing all the time. Many contracts are now concluded on WhatsApp. If there is a proven exchange between the parties, I offer, you accept, and these are put to the tribunal, proof of that exchange is put to the tribunal, that would show the intent. If there is an intent to do the business to be legally bound, that would be accepted. It's the same question. Arthur, if you were to make an offer to sell to me 10,000 tons and I accept over the telephone, the jurisdiction of that contract would be here, English law, because I have confirmed to you from my position that I intend to be bound. The English court would do that. If we reverse, if I'm sending to you and you accept by telephone from Odessa that you accept my offer, then the English tribunal would say the jurisdiction of that particular contract would be Ukraine. So the exchange of WhatsApp messages reflects that position. It's the point of acceptance. If the parties are trading, have agreed trade association standard terms, GAFTA, Phosphor, Bristol Corn Exchange, whatever, if that standard term has a domicile clause which says everything to be decided in London, English jurisdiction will be applied. But it is evidence of the intent to be bound would have to be shown. The exchange of the WhatsApp messages would have to be put to the tribunal. Does that help?
Okay, yes, clear. What about the next question is about proofs. You just explained that if there are proofs of making a contract in a messenger with the intention to make a contract is okay. So what proofs can be presented? I mean, simple print screen, something like that can be considered a proof. You know,
yes.
In countries where continental law is used, you know, lawyers, judges, they are very, very delicate with proofs.
Everyone should be delicate with proof of a fact. But if both parties are clear in what they put forward, we've often seen in trade arbitrations, mountains of evidence. Every conversation on WhatsApp is put to the tribunal, and you have to go through it. And if we can see that the parties are genuinely negotiating and coming up with an agreement to be bound, they come to an agreed term, it's generally supported by the broker issuing his confirmation email saying, okay, the WhatsApp exchanges are over, the contract has been brought into existence, here is the confirmation. That would help. If there's no broker involved, then the tribunal itself has to look at the volume of the exchanges, what is said, and to decide for themselves that at a certain point, this is evidence of an intent to be legally bound, and that the parties have reached an agreement to buy and to sell on equal terms.
Thank you, Richard. Another question from the chat. Will GAFTA arbitration hear the case if one of the counterparties are not the member of the GAFTA?
Yes. You do not have to be a member of GAFTA to use the arbitration services. In fact, I would imagine the majority of contracts on or people who use GAFTA contracts are not members. If there is a dispute, all right, the matter goes to arbitration, an arbitration award is issued. If you are a member, you pay a discounted rate. If you are not a member and you win the arbitration, you have to pay the non-member fee. So GAFTA will not bar you from the arbitration simply because you are not a member.
Thank you, clear. Next question, very practical one. If contract agreed terms of payment, but the buyer delayed to proceed with the payment, cargo is already on the way to the port of discharging. Next steps.
This is always an interesting one, and as Arthur knows, we've had a few cases where ships have sailed off without paying for the cargo. You then have to go to the Sale of Goods Act. We take it that there are shipping documents in existence, so we have a valid bill of lading, valid insurance certificate. Shipping documents have been presented for payment, but they are refused. If they are presented under a letter of credit, then the seller has protection. If the shipping documents are in order, the bank has an obligation to pay. If it is a cash against documents, then refusal to pay means that the goods are in transit. The seller is without physical control of his cargo and has no money. You then go to Section 19 of the Sale of Goods Act. There's an implied term that the unpaid seller still has property and title in the goods. If you are in that situation, then you need a lawyer at the port of destination, because you would have to take steps to order the master not to discharge because you own the property and the title. The shipping documents would have to be retrieved if possible. Cash against documents, they may be sitting in somebody's trading office. So you would, the unpaid seller would need to look to Section 19 of the Sale of Goods Act, take steps to get the master not to discharge, even if an original bill of lading has been presented. You are immediately in court. You are outside of an arbitration dispute. You need to be practical. You need a court order to establish that this buyer has not paid, even though he has possession of the bill of lading. He is not entitled to take delivery, to demand delivery from the carrier. These cases do come up. you have to move very quickly and you have to be very certain about what you are doing.
Thank you very much, Richard. The next question. You have mentioned above arbitration rules for GAFTA 125. Are there the same arbitration rules for FOSFA?
There are arbitration rules for FOSFA, the rules of arbitration and appeal. I use GAFTA 125 because that is the most common form of commodity arbitration. All trade associations will have their own arbitration rules. I've just used GAFTA as an example.
Dick, are they available in public?
I believe it used to be that they weren't, but I believe that generally they are publicly available. If the trade association doesn't, then you can probably find them on YouTube.
Great. Today we have many questions, so it's very good. We are quite interactive. The next question is, quite often we see in correspondence the phrase "without prejudice." And sometimes it is, such phrase is put as a, let's say, absolute excuse, How you may comment on that? What in reality without prejudice means?
Briefly, without prejudice appears everywhere these days. The general position, I believe, is that if there is a matter to be disputed, a matter in dispute, and parties are attempting to negotiate, they can negotiate and come to a solution without prejudice, which means that that discussion is private. It cannot be made public. We often see an argument as arbitrators, and I believe judges, that we're given a piece of paper showing that an attempt to negotiate a price without prejudice, or to negotiate a discount because of a problem without prejudice. That should not be shown to a tribunal or the court. It would not be accepted. If the matter breaks down, then the parties are free to say, we have attempted to reach a solution, we have failed, but there may be points raised in without prejudice at WP discussion that could influence a judge or an arbitrator because they give away a little bit more information. So it would be unfair for those private discussions of an attempt to reach a discussion, to reach a settlement, to be made public. So yes, without prejudice is used as an excuse these days. It is strictly limited. I can provide a sheet on this if you require. You can put it on your website. I think you may already have one, actually. So yes, be very careful. Be very certain that if you are entering into WP without prejudice discussions, they are kept private and confidential.
Thank you. Next, you said that under English law, it is not necessary that a contract is made in paper. But as per continental law in some countries, contracts should be made, not only made in writing, but should be signed,
and
stamped,
yes,
or sealed.
Yeah.
Yes. And what about how does it correspond to commodity, English commodity trade law?
Well, the simple answer to that, it comes back to, if you have agreed to trade on a trade association, an English trade association contract, you do not have to have a contract signed, stamped, or sealed. There are exceptions in English law. The sale of land requires the contract to be in writing, but for commodity trading, no, it does not have to be signed. You can have a telephone conversation which can result in a binding contract. I've had to deal once with a trader giving me a white serviette from the restaurant saying, here are the details of my contract. It does not have to be in writing.
Can anyone use pro formas of GAFTA in FOSFA? Once I attended a conference, and a speaker at the conference said that only members of FOSFA and GAFTA can use standard pro formas that are developed by these associations. What about non-members?
I see no reason why non-members cannot trade on GAFTA contracts. I'm not aware, I mean, I could be corrected on this, I'm not aware that GAFTA charge a fee for traders who want to use their standard form contracts. The answer again comes back to my previous comment. If you are a non-member, you can still claim arbitration at GAFTA. You simply have to pay a different fee, a higher fee.
Okay. Do these trade associations, GAFTA, FOSFA, do they have a blacklist?
They have lists of defaulters.
What does it mean?
Defaulters are people who have not paid arbitration awards. That, I think, is as close as you can get to a blacklist. So if you are trading with a new partner or somebody comes and offers to you, it may be worthwhile to see whether that company appears on the defaulters list at GAFTA or FOSFA or other trade association.
So it's a kind of reputation protection.
Yes, very much so.
Yes, because similarly, BIMCO, Baltic Shipping Associations, also has a similar defaulters
yes, yeah,
list.
Yeah, that I think is as close as you get to a blacklist.
Yeah, very close. Yes, very close to that. One more question about the role of a commodity cargo broker. How is its commission guaranteed? We know that mostly there are no contracts with the cargo brokers. They are mentioned in the trading contracts.
Yeah.
Do you know that there are cases when cargo trade brokers go to arbitration to recover their commissions?
Yes.
How is it regulated?
In the same way as any other arbitration. Yeah, there's a contract. The parties have agreed to use a broker. The parties have agreed who will pay the commission. If that commission is not paid, the broker has a right to claim arbitration.
So the broker can use the same arbitration clause.
Same arbitration clause
between the parties, right?
Yes. Yeah.
Yeah. Okay, I just want to add that we have a lot of another questions, but first of all, it is enough for Richard today, and tomorrow we will also have the practical part of the about the trade. So other questions will follow tomorrow, and we will give answers for them in any way.
Okay. So I wish you good luck with the rest of the webinar.
Thank you, Dick. Yes. So now it's time for Jean-Paul
Yeah. Okay, I'm with you.
Yes. Here you are. Yes. Okay. The floor is yours.
Thank you, Arthur. Thank you, Interlegal, Black Sea Nautical Institute, and a very interesting presentation from Richard, actually, which really helps me putting the rest of my presentation actually in perspective. But without further ado, let me try and share my screen.
Merci, Jean-Paul.
Let me see if that works. Okay. Okay. If
We can see it, everything is okay.
okay. So I'll quickly, I mean, what we saw from Richard's presentation is that, you know, even though, I mean, like Richard said, it's basically quite simple, but it can also be quite complex. And especially if we dig into the legalities and the complexities of drawing up sales contracts. And this is what leads to chartering vessels, and also will confront us with the matters of lay time, demurrage, and detention. I'll quickly introduce myself. A couple of years, actually over a decade ago, I was working as a shipbroker, and I recall one instance where actually we chartered three separate vessels on three separate occasions for the same charter, going to a specific port. And in each port, we as a broker, we knew we overrun the lay time, you know, the allowed time, meaning we were expecting a bill of, and this was close to $30,000 at the time. So three separate cases, 3 times $30,000. There was a 90-day time bar. We will come to that in a moment also. And none of the occasions we received the bill. And none of the occasions, not after 90, you know, before 90 days, not even after 90 days, we never received a demurrage bill. And that got me thinking. I came out of the crisis. You know, we had the banking crisis. Actually, as a broker, that meant that all of a sudden your income was slashed from, you know, with 94%. As freight rates tumbled, and your commission is paid based on the freight rates that you fix. So I really I kept this in my mind, and then during a course of ship finance, I was told that, you know, ship owners, 26% of respondent ship owners were concerned about operational follow-up. And then leading on into that questionnaire from a quite blue chip legal company, which I won't mention, it said only 6% was going to invest in operational follow-up. So that got me thinking, and that's how I really you know, swapped my career from being a shipbroker to being a laytime analyst. So that's a little bit about me. What I will try to do is, leading, we saw from Richard, it really requires some time. I mean, if you really want to dig into this and want to do this in a really professional way, it's quite important that you grasp the matter, and that you know what you are talking about. And it can be sometimes daunting, I think. I mean, especially for new entrants into the market of, you know, you've done that sales contract. We will come to that also in a minute. You've done that sales contract, and then you need to fix a vessel. You need to find a vessel to carry your goods, to, you know, to fulfill your sale. And it, you know, it is it can be really, like I said, really daunting and challenging. Purely by the legality and the jargon that you will be confronted with, and my aim today is try and bring a little a light version, as a matter of speaking, a more simple approach to what it is. I'm not saying that I will achieve all the time. I will not promise that I will achieve it all the time, and that, you know, if you have questions, do ask them. I started writing, as you can see from the presentation a while ago. I started an attempt to writing a sort of a playbook. You could say a childish, or at least a simplistic approach to lay time and Demurrage, and that's where what we will do today, and where we will go in the next hour. So let's kick this thing off. As you will also see, there's a lot of text because these are extracts from a book. I won't spend too much time, but the nice thing is, after this presentation, you will be able to get this from Interlegal as a participant. You will be able to use this as a reference. You see, I'm referring here to lay time sometimes as the dinosaur in the room can be intimidating and challenging to navigate. And if you ignore it, then it can definitely come back and bite you where you don't want to. But I'll try and, you know, with these steps, I'll try and guide you to tame the dinosaur. So today we will go, you know, as Richard very in detail discussed, you know, the sale of goods, sales agreements. Then we need to fix a vessel. We need to draw up a charter party. What we heard that we not necessarily, we could just, you know, exchange WhatsApp messages perhaps, but you'd want to draw up a charter party just to make sure that your risks are not, you know, exposed, and you're not exposed to risks. That's what I meant to say. And also that, you know, that your rights are reserved, and you know your obligations in the contract. Then lay time. Lay time is a sort of, you can regard lay time as a separate contractual bubble within the charter contract, because it has its own sets of terms and definitions, as we will see, you know, as we go. Then we will one of the topics that we will look at is how is it calculated, what stops the clock, and so on and so on. What starts the clock? You know, when does lay time commence? And then after that, we'll automatically land, as you will see, or sort of organically land in the territory of innovation, industry innovations and technology, to finalize with the training and continued education. So if we jump to sales, like Richard also mentioned, you know, it's important that from the shipping side, we understand the terms, and very important that we do understand, or that we do try to align the terms that we agreed in the sales contract, that we can also mirror in an ideal scenario, that we can also, that they are also reflected in the charter party, which is quite important, as we will see. So the voyage charter party relies on the sale and purchase of the cargo, but sometimes it can be hard to synchronize the terms, and especially if we know that the sales contract is agreed sometimes you know, substantial time before fixing the vessel. So the chartering is only done, you know, or the fixing of the vessel is only done, you know, usually after the sale has been concluded. So it's quite important that the terms are aligned. If you agree to certain elements, let's say to a window of presenting the cargo, then it's quite important that that also is reflected in your charter party under laycan and so on. Delivery windows, also the lay time, you will probably have agreed to a loading or discharging speed, or a number of days to load or discharge. Well, it's quite important that you are not caught out in your chartering contract, agreeing one thing in your sales contract as a trader, and then being unfortunately confronted by by a misalignment, so to speak, by different terms. So it's quite important that we get those things on the same line. So there's I've mentioned there's the roles. We have buyers, sellers, same as Richard also in his presentation mentioned. There's bankers, there's cargo, there's structured finance. There's a lot of things to keep into in consideration. And we had the actual sales agreement, letters of credit, the sales invoices, quantity and quality surveys, certificates of origin, export documents. So they all play a role leading to the fixing of the vessel. Maybe something to take away is that in FOB sales or in FOB terms, the receiver is the charter, and in SIF terms, it's actually the shipper who's the charter. And just one thing on that to continue, that is the trader, the actual owner of the cargo, is not always the charter. It might be that they use a company that could be a forwarder or a broker to take up that role, that takes on the role of the charter. So, but that still means they are the shipper. So just to point that out. So the lay time under the charter party, lay time under the sales contract is between the seller and the buyer. Under the charter party, it's between the charter and the ship owner. And the charter party sits outside the other agreements which the charter may be a party to. So the ship owner has no obligations to whatever terms you've agreed in your sales agreement. That's a totally different contract. Still, it's important that those terms match as much as possible, ideally. So then that takes us to the next step. We want to fix the vessel. What's important there is supply and demand at that specific time that we need to, or that we want to fix our vessel, freight market, market intelligence. And also I've mentioned also shipbrokers, and we come to that in a second. So the role of a shipbroker can be quite interesting. I mean, if it's a good broker, because they will give you a helicopter view of the market, of what's going on, and so on. Perhaps also, I mean, using a good broker, sometimes we have a good relationship with the ship owner. You've been doing business with them for years, and you're happy with the way things are going. Or you're involved in a very, let's say, fixed trade. Let's say you're shipping iron ore from Australia to China, and that's all you do. And there is little value that the broker can add, because those freight rates are published. The vessels, the vessels that are plying between the two ports or the two regions, it's always the same vessels, the same market, the same rates. So then it becomes very difficult for the broker to add value. What can he tell you? He will tell you something you already know. He will tell you, oh, the freight rate's $7 today, and you will know this because it's what you do. It's a totally different picture if you're dealing with the same commodity but different ports, different regions. You want to know, what are my competitors doing? What cargoes are in the market, perhaps from my competitors? What is the amount of vessels in the area? And as we know, lots of vessels, very few cargo, low market. Lots of cargo, very few vessels, a higher freight rate, freight market. So, and it's quite important to keep in mind that the ship owner calculates the minimum required freight by a reference to a voyage estimate. And one key component of that is time. So any variation in that time, if a ship owner assumes that if he fixes a vessel with you and he assumes that this trip will take 40 days, including loading and discharging, and now all of a sudden it turns out instead of those 40 days you spent 10 days extra in port. Now the owner needs to be able The ship owner needs to be able to compensate those expenses, and that's why you agree in the charter party, where we'll come to next, that you will compensate the ship owner for the loss of time. For actually, like we said, the ship owner assumed that his vessel would be occupied for 40 days. All of a sudden, it turns out it will be 50 days. Okay, that either if there is no remedy for that, that means this will eat into his profit, into his margin, or maybe even present a loss. So that's obviously not where you want to go. And that takes us to the charter party. So, like we said, you could exchange, and this often happens. You could exchange WhatsApp messages, Messenger messages, exchanging an intent to, you could be with communicating with a broker, you could be communicating with a ship owner directly, and you could say, hey, listen, I want to fix a vessel, and this is what I have in mind. And then most probably the broker or the ship broker will return and say, listen, let's continue this on email. I will write you an email. Maybe you have already summarized let's say the main terms of what you want. You want this vessel, I don't know, from Brazil sailing to China, from Odessa to Western Africa, and this is what you have in mind. You have the amount of cargo based on your sales contract, the amount of cargo, the loading and discharging terms, more or less, and then either the broker will go into the market, find the vessel like we just saw, or the ship owner will start calculating. But to do that, he will need more details. So the main terms, as we say, will probably be exchanged through email on what we call a recapitulation of what has been agreed in that messenger, in that telegram, and that whatever channel you are using. But it is obviously, like we learned from Richard as well, it's obviously quite important to have these things written down. Then the main terms will lead to a charter party, and those main terms you could fix like you will often see on subjects. Subjects will mean that you agree on the main terms, you agree with the owner, this is what we will do, and basically saying that we've agreed, but the charter party, the contract in itself is not finalized yet. We still need to exchange a number of terms and conditions that we would like to see in that contract. And keep in mind, I always explain that to students or to people wherever I speak. Keep in mind that whenever you are trying to obtain something to your benefit in a contract, challenging, or where you do a concession, or where you want the ship owner to make a concession, it will always reflect in the freight rate. If you want a faster loading speed, okay, that's okay, but it might have its effect on the freight rate. If the loading speed or the discharging speed will be slower, if you will need more time in the port, it will have. You cannot expect, if for instance, if a ship owner calculated 40 days and you present your loading and discharging speeds, and all of a sudden the ship owner realizes that, hey, this is going to take 5 days longer at this loading and discharging speed, you cannot expect that you will get that the freight rate will remain at the same level, that the freight rate will remain at the same price. So it's quite important that that you keep that in mind. Every concession you want the owner to make, or any challenge to that contract, will have its effect to the freight rate, basically. Now we also see there's quite a number of specific contracts. We have contracts are based, commodity based, iron ore, coal, or grain. Like you have the Amwell, Schnorr grain, Sinocomex, probably contracts or things you already heard heard about, cement voyages, and on specific company-related contracts where the big oil companies really set out their terms, and if you as an owner then want to fix with one of those companies, these framework contracts are quite straightforward. As we see that the roles here are quite, let's say, more limited compared to our sales contract. We have the ship owner, the charterer, and potentially a ship broker. One of the points that Richard also mentioned was the freedom of contract, is that you're free to agree any terms that you want to under English law. That's one of the building blocks, one of the strong points of English law. And the business of courts and arbitrators under English law is to give effect to what you have agreed on. So, and from there on, we come to the next contractual bubble, because you've now, let's say, you fixed the vessel, you've drawn up a charter party, and you've agreed on a number of terms. And we will specifically talk here about lay time because it's quite important, and it's one of the most disputed, let's say, one of the most common issues, and where I step in sometimes as a commercial mediator specialized in demurrage disputes. It's one of the most common disputes we come across. So that brings us to lay time. For some, maybe playtime. For me, for instance, I'm really fascinated by lay time. You could think it is quite a boring subject in a sense, but it can also be very fascinating if you take the time to, or if you have the time, to be honest, to dig deeper into the matter. So enter the dinosaur, as we said. And we need to treat it very carefully. And by the end of this presentation, at least I may have shown you where the whip lays to tame the dinosaur. So a couple of practical insights. Lay time is only found in voyage charters. There is no dispatch in tankers, and lay time regimes also exist under sales agreement, as we saw. There is no dispatch in tanker trades because the loading and discharging speeds are a lot higher in tanker trades, where, like I just said, where, okay, the voyages might also be 40 days, but the loading and the discharging is often a matter of hours, 24 hours, 48 hours, 96 hours maximum. So you see, there is very little benefit or very little effect for an owner to allow dispatch, as it, the effect on the voyage will be very minimal compared to dry cargo, where you could have a voyage of 40 days and in some cases perhaps spend 10 days, or the owner perhaps calculated that he would spend or assumed 10 days in port for discharging alone, for instance. So there it's quite there is an advantage for the owner and the charter to come to terms, in the sense where the charterer says, listen, you've calculated your freight rate for me based on the vessel being occupied 40 days, but now all of a sudden it turns out we only used 35 days. So I actually saved you 5 days. So, Mr. Owner, what do you think? Should I not be entitled to a discount? And that discount, called dispatch, is usually half of the demurrage. I won't go in too deep why it's half. There's a number of reasons for that. But it's basically a commercial gesture from the ship owner to the charterer. So, okay. So the charterers are entitled to play a game of tennis during lay time. Did you know that? Or football or baseball. And the reason for that is because charterers buy the freight, they pay for the use of the vessel. they are entitled to those. Let's say that the ship owner has calculated that you would use his vessel for a period of 40 days. That is what we will come to that in a second, because the ship owner uses the time that you'll be occupying his vessel. So you've paid for that. You paid $1 million for your freight to be shipped. You're entitled to that time in the port. If it's, let's say, to make it simple, if you're entitled to 5 days loading, 5 days discharging, well, that's exactly what you're entitled to as a charter. Whether you use that time to load or to play tennis in the hold, like we see on the picture, that's up to you. And perhaps a little more, digging a little more into the matter of how, why time is so important for a ship owner. The charters want to minimize the freight cost. Charters will get, a freight on a per ton, $1 per ton basis or a lump sum basis. A ship owner wants to maximize his earnings on a $1 per day. So how does he compare that? Let's say you're the charter and you have this price ID of $1 million. You fixed a few months ago at $1 million. You don't know what the market has been doing, but that's your idea. That's where you want to go. For the ship owner, he will need to take your $1 million offer and compare it to what the market is in time charts. But the problem there is the market is for the ship owner is reflected in a higher and time charter equivalent, as we say. To make that comparison for the ship owner, they will do a voyage estimate, which is a mathematical exercise to convert that voyage freight into a $1 per day result. So basically, he will look at that return, that revenue, the freight rate, or the freight times the tons of cargo, his revenue will deduct his costs and divide that by the duration, by those 40 days, and that will give him $1 per day earning. So it's quite important, and obviously, like we said, that lay time, the longer it will take to load and discharge, the more effect this will have on the profitability of this voyage and on the TCE of the vessel. And this obviously will differ in strong market and in high markets or in low or weak markets. So once let's say we're clear about that, we've got this, our offer from the ship owner. That takes us to who bears the risks of delay. So we've now fixed this vessel. The vessel needs to come, let's say, I don't know, I'm based in Antwerp, and the vessel needs to come from Flushing. That's the ballast voyage or the approach voyage. And that's the ship owner's risk. When loading, the vessel arrives in the loading port, vessel arrives in Odessa, for instance. All the time that the vessel spends in port is at the charterer's risk, the charterer's cost and time. The laden voyage, again, vessel is loaded, it leaves the port and it continues to its discharging port. Any delay by weather and so on, by perhaps breakdown, God knows or God forbid, during that voyage is on the ship owner's cost and risk of time. But again, once the vessel arrives at the discharge port, it's the charterer's risk. So in general terms, the ship owner bears the risk of delays during the sea passage, and the charterer bears the risk of delays during loading and discharging. So, and that takes us to calculating lay time. So there are 4 questions to consider. So now we know, our vessel, we run a risk when our vessel is in port. So how much lay time has been agreed upon and how is it calculated? Well, there are 3 ways to calculate lay time. One is definite lay time, total hours or days, all purposes. Could be cargo to be loaded and discharges in 10 weather working days of 24 consecutive hours, all purposes. There is calculable. that's a fixed quantity of cargo to be loaded based on the amount that you intend to load, and usually that's the amount on the bill of lading that we use or discharge, divided or discharge per hour or per day. So basically calculable as the lay time is a quantity of the cargo divided by the daily rate. So if we have 40,000 tons, the daily rate is 10,000 tons, while we're allowed 4 days to load. If it's we've got 40,000 tons and the loading speed is 10,000 tons per day, again it's 4 days. So we see the distinction there. There's also the indefinite. You will perhaps come across an indefinite lay time. For instance, when booking cargo on liner terms. And liner terms, in liner terms, the ship owner takes on the risk for loading and discharging. It takes on the risk of time and the cost as well. So basically, if the ship owner runs a delay there, that's the ship owner's risk. Other terms are customary quick dispatch, custom of the port, fast as can. These are all very, let's say, have a negative impact on the lay time from a ship owner's perspective. Because what happens here, while indefinite, while we look at definite terms, the ship owner knows exactly how much time his vessel will spend in port, or at least what you've agreed on. You've agreed on spending 10 days in port, 5 days, or it's calculable. Again, he will know it'll take me 4, 5, 10 days to load or discharge. With indefinite, the ship owner doesn't know. And that's also why I don't come across it in my practice here. But that's why, you know, I think ship owners will shun away from it, because it's you don't know how long your vessel will stay in port. And you see the difficulty is, imagine you've assumed that your vessel will be occupied 40 days. You've assumed that as a ship owner, the vessel will be occupied 40 days, and you've agreed to indefinite loading and discharging terms. Basically, you don't know how long your vessel will be kept in port, or custom of the port. Will it be 2 days? Will it be 20 days? You don't know. So you run a huge risk of overshooting your freight rate that you've offered to the charterer. You've offered $1 million, and all of a sudden, instead of 40 days, the vessel ends up being used 60 days. So, you know, there goes your profit, and it actually turns into a loss. So how much lay time has been agreed upon, and how is it calculated? Quite important point. And then let's say we've agreed on all this and we know where we stand. When does it start? Well, from a legal point, the vessel needs to be an arrived ship. And what does that mean, an arrived ship? It needs to be at the right place. It needs to be in the right condition. It needs to tender a valid notice of readiness. So at the right place, quite importantly, we could refer to this as the berth charter party, or make the distinction between a berth charter party or a we will come a bit later to the commencement of lay time, a port charter party or a berth charter party. There's quite a distinction. I could say vessel to load one safe berth in Odessa, or I could give a specific berth, berth number 7 of the grain terminal in Odessa. That's a berth charter party. Or I could say Port Odessa, one safe berth. That's a port charter party. So we will come to that in a minute on the right place, the right condition also. Usually, if you're familiar with notices of readiness, you will see that the master, through the notice of readiness, will declare my vessel is ready to load cargo in every respect. Meaning, you know, my vessel, you know, is in a working condition. The holds are clean, the cranes are working. So the right condition is quite important. We'll continue and elaborate a little bit on that on commencement of lay time. And a valid notice of readiness needs to be given, meeting all the above points. But it also means very often the charter party will stipulate, first of all, who does the master need to notify of his readiness? The agent, the shipper, the receiver, the stevedores, could be anybody, specific persons, and also the right time. It could be that the contract stipulates the vessel is, we're loading checks, Sundays and holidays excluded, sorry, but that may not always apply. Or let me rephrase that. Let's use Shink. So let's say we will use loading and discharging Sundays and holidays included, but this might not necessarily apply to the time when notice of readiness can be tendered. And you will find in every charter party, mostly the tendering of notice will be handled in a separate clause saying, okay, we are loading Sundays, holidays included, but notice of readiness can only be tendered during office hours. And then they will stipulate office hours being from Monday to Friday from 8 till 1700, and they like to use, as you probably know, lots of abbreviations in shipping, ATDN Shink, anytime, day or night, Sundays, holidays included. So where in one case you're only allowed to tender notice during office hours, and the other case being you can tender notice whenever you like. The distinction and the importance there is that if it's office hours and the vessel arrives, let's say on a Friday evening after office hours, the master tenders notice of readiness. This literally means that the notice of readiness is only valid, only kicks in, only triggers the lay time clock on the next working day, being Monday 0800. And having said that, if Monday is a holiday, an official holiday, it might actually be Tuesday. So from a ship owner's point of view, that's you stand to if you agree to terms of office hours, there is a chance that if your vessel tenders notice outside of the office hours, there is a risk of losing time. But having said that, there are also terms absorbing this and providing a remedy if that happens, or providing no remedy at all. Where it does not allow the ship owner to tender notice of readiness before, let's say, those office hours, or in some contracts, it might be that they've come to an agreement that they might work the vessel during holidays anyhow, but we will come to that more into detail in a moment. So what suspends the time? We know now how much time we have. We know when it starts. What actually stops the time? Obviously, when lay time, when operations are finished, that's clear. But in between, what stops the lay time? Default of the ship owner, vessel breakdown, and so-called express provisions, interruptions, exceptions, such as strike. But those exceptions, as we will come to see in a minute, can be quite comprehensive. And then when does that clock literally stop? When does lay time stop? Traditionally, when the loading or discharging stops, when the operations stop. But the parties can agree on different terms. Sometimes you will find contracts where it says that lay time stops when the documents are handed over to the master, or when the documents are on board. So what do we need to calculate that lay time? Just quickly drop this down here. What do we need? What documents do we need to calculate lay time? We need the charter party to know, what have we agreed on. We need the statement of facts, and a statement of facts is a chronological overview of what has happened and while the vessel was in port. There are a number of forms, for instance, BIMCO form, but to be honest, I come across different statement of facts throughout the day and throughout different cases. So let's say the standard statement of fact is not yet a fact. We need the quantity loaded, bills of lading, the stowage plan. I won't go too deep into this on a working hatch or pumping log for tankers. And then we go through the stages of calculating. So how we know now, we know how much time we have, how much time is allowed. We know when we started, how much time have we used. So how we will come to that? Well, we'll read the charter party, we'll find the terms. We have to find the terms of the, that we agreed on. We obtain the necessary documents, as we said a minute ago, statement of facts, bill of lading, notice of readiness. We calculate the lay time duration. It might be, very straightforward, 10 total days all purposes, or it might be 3,500 tons per day pro rata. So we calculate the lay time duration, the allowed lay time. We establish when lay time begins, allow for the interruptions. Interrupts could be rain, could be draft surveys. There's all sorts of interruptions and exceptions that might occur whilst the vessel is loading or discharging. We establish when lay time ceases, and that will give us the time we've used, and the result of that will be either demurrage or dispatch. So let me go to the next slide quickly. So we come to those express clauses. So the clauses which define lay time, like we said, 10 working days, Sundays and holidays excluded, or exception clauses, time lost by reason of strikes, bad weather, shall not count as lay time. Time does not run in the case of clauses which define, even if no work was actually being done. But I have something to add there. So let's say we have Sundays and holidays excluded. So that means lay time will not count, even if let's say the charters have a good agreement with the stevedores and they decide, well, it's weekend, but our teams are prepared to work throughout the weekend, Sunday, holidays, doesn't matter. Then we will find most often we will find an additional abbreviation there, which will say time not to count EIU, even if used, or UU, or unless used. And to make it even more fun, sometimes it will be Sundays, holidays excluded, unless used, actual time used to count as half. So basically what it means, and it's a normal proposition, basically what it means, Sundays and holidays are excluded. We will not work during Sunday and holiday. We will not work in the weekend, unless, if we do work, then the lay time will only count half. So this is in the benefit of the charterer. And it's also actually a concession to the ship owner. But it might also be, if it's, even if used, it might be that the charterer will not make a concession on his lay time, even if he works, the vessel has worked throughout the weekend. So the charterer says, I don't care, I'm entitled to my lay time, and the contract says Sundays and holidays are excluded. Well, that's what it is. So, but time stops running under exception clauses only if the specified event has actually delayed work. For instance, rain whilst loading cargo. But imagine if you're discharging project cargo and the rain does not affect the loading or discharging of your cargo, then obviously, if you continue, there is no stoppage. It has not prevented you from loading or discharging. So the principal difference between the two is that with the latter, it is necessary to show a causal connection between what is accepted and the failure to work cargo, whereas with the former, all that needs to be demonstrated for causation is that the excluded state of affairs, for instance, a holiday or a Sunday, exists. you don't need to prove it. With an exception, you need to prove that exception. For instance, we stopped for a draft survey. There was 1 hour draft survey. Well, you know, the statement of fact need to record it, and it needs to be shown. The master will have signed off on the statement of facts. I agree. Indeed, we stopped 1 hour. This is an exception. We stopped 1 hour for taking, you know, a draft survey. That's an exception. I won't go too much or too deep into whether working days, but there's a small example here. So ship A has a port chart, because we were talking about, you know, port charter parties. It has a port charter with an interruption to lay time expressed in weather working days. And ship B has a similar charter with lay time expressed in working days and an additional clause. You know, you see here, weather working days, that's a definition. We defined those days there. They have to be weather working days. And with ship B, we only have working days, and we've put the weather actually in an exception clause. So if both are waiting at anchorage for ship A, the rainy periods on working days will be excluded from lay time, even if, you know, it means you have to treat the vessel, if it's at anchorage, the vessel needs to be treated as if it was at the berth, and that means if it rains at that moment, even though the vessel is on the anchorage, it means that it's entitled to deduct that the rainy periods, whereas ship B would not be able to do that because there is no time lost to adverse weather. That exception clause does not kick in, so can be a little, or you know, can be confusing. And I have to say that the courts now usually line up the same, you know, whether working days or working days, weather permitting, and so on. See them as the same term. So another thing that we may come across is we often come to the term non-reversible average and non-reversible lay time. So reversible lay time favors charterers. If lay time is exceeded at the load port, you can make it up at the discharge port. Demurrage FENI can only be calculated after discharge payment. But the thing is with reversible lay time, you have to wait. In the normal condition, let's say in non-reversible lay time or demurrage is calculated for each port, you know, the time allowed and the time used, either demurrage or dispatch, and it's actually payable. You know, at the load port, you've incurred demurrage. The owner is entitled to send you an invoice already after the first load port, and you incurred demurrage. Then the owner is entitled to send you a demurrage bill. If on the other hand it's reversible, that means that the owner will have to wait until until also the operation in the discharging ports is finished, because you've given the charter the option of reversible lay time, meaning that he can, if that's the case, deduct his demurrage or dispatch from the demurrage or the dispatch in the first port. So it's an option given to the charter to add also sometimes together. So let's say by calculation we've come up through the loading speed that lay time in the load port was 2 days and discharging time allowed is 5 days. Well, now under reversible option, you are as a charter entitled to throw those together, and 5 days loading, 2 days discharging become 7 days all purposes. So we see quite a distinctive difference. And then average, it's also separate calculations of time in one operation. So any time saved in one operation, dispatch time is set off against time lost in another. And you see that in this slide, if you go to non-reversible, I've put dispatch money in italic, and in average, I've put time lost in italic. And the difference there, it might be a little confusing when I explain it, is when non-reversible lay time, the money earned at the ports is offset by the dispatch money at the end of the calculation. So let's say you have $20,000 of demurrage, and let's say and the demurrage rate is $10,000. So that means dispatch, you're entitled to 50%, half the demurrage. So you're deducting 5,000 from 20,000. So you end up with a $15,000 demurrage bill. But I've got an explanation in more detail in the next slides. When it's average, we're actually deducting time. What's happening here is we have 1 day demurrage and 1 day dispatch. So 1 day demurrage 10,000. Now we're deducting time. We're deducting a day. So 2 days minus 1 day makes 1 day. 1 day demurrage is only $10,000. You see, there's a difference now of 5,000. You are paying $5,000 less. So this can be a bit confusing and daunting sometimes to grasp. But as you do, or you get into the detail of it, it becomes easy to see. So we'll go to a couple of examples in the next slides, as you will see. So here we see the loading port, and like I said already, in shipping, people like abbreviations: per day, pro rata, demurrage, half dispatch, both ends, all time saved. And we will come to that all time save or working time saved as well. But like you see, people shipping, they like abbreviations. So at the loading port, the charter uses 2 days more than allowed, than the allowed lay time, thus incurs demurrage at the demurrage rate, like we just said, $10,000. The charters are liable for $20,000 of demurrage. And a non-reversible offsetting, in a non-reversible case, we will be offsetting money. We will be offsetting 20,000, or actually, we have the dispatch, and dispatch, we saved 1 day, but since it's dispatched, it only counts, half demurrage, $5,000. We deduct that from the $20,000, and we end up with $15,000 demurrage. If it's average, we're offsetting time. So there's 2 days of demurrage. We've got 1 day of demurrage here. What happens now is we deduct that 1 day from the 2 days, and we're left with 1 day. But look at this, for $10,000 at $10,000 a day demurrage, we end up now only being responsible for a $10,000 demurrage claim from the owners, opposed to $15,000. You can take this even further if you, through your sales contract, have agreement with your receivers. But I won't go into detail because that really makes it complex. But you could turn it into sort of a dispatch trade, as some traders sometimes tend to do. But that really becomes complex, and it also means that, like we said in the beginning, that the sales contract and the charter contract really needs to be aligned, or you really need to have a good control over what happens on the shipping side, and being able to absorb and cover the risks involved. So if we take those, that example, and we pull this out into let's say in a mathematical approach. Here I've mentioned this as the normal non-reversible position. But as a good friend of mine pointed out, that's normal in the dry cargo business. For tankers, actually, it's the opposite. For tankers, usually it's the reversible condition that is used. So basically, I won't go too deep into detail of the formulas, but basically what we're doing is that we establish the allowed time for each port, deduct the used time, and that will give us a result. If the sum is negative, money paid by the charters, demurrage. If it's positive, then it's paid to the charter and its dispatch. And you will see that under every port, it's the actual time minus the use time times demurrage. Obviously, I assume that demurrage in each port would be the same for the entire voyage. And it's very unlikely that it would be different, but I just made a note about this. The case when looking at average, the average regime and the same approach, we have the allow time and the use time, but then it becomes a bit different because we're going to deduct the use time from the allow time for all the ports, and then the result will be multiplied with the demurrage. And if we take it a notch further, we'll go into the reversible. And the reversible, again, just if you take a look at it from a mathematical point of view, it's just a different approach, and it helps to clarify the way things are. Basically, you're deducting used time from allowable time. If it's negative, it means you're owed demurrage. If it's positive, then it means you saved time, and for that saved time, you're allowed dispatch. Which brings us, I won't stick too long on the formulas, but which brings us, since we're talking about dispatch, what else affects dispatch? So there are two methods of calculating dispatch, and we saw if we quickly go back to the first slide here, it says ATS, all time saved, and then the difference is we have all time saved, but we also have working time or lay time saved. Working time saved is often, or sometimes expressed as a lay time saved, which is the same thing. We will come, especially if it's, there are trades where there is no dispatch. For instance, like we mentioned tankers, but also short sea. And the reason for that is in short sea trades, the vessels usually don't spend a lot of time in port. Might be 24 hours a day, 2 days, but not too long. So the benefit to the owner is lost there, or is negligible. But obviously, if we look at this example, if we look at all the time, we're talking about 9 days and 23 hours. So here we see where it says working time saved, all time saved. We see discharge completed on Sundays with 7 days remaining on the clock. So we've got 1, 2, 3, 4, 5, 6, 7 days on the clock. Now, that's based on checks. And if we're talking about working time saves, we have the Monday, the Tuesday, the Wednesday, the Thursday, the Friday, and again the Monday, the Tuesday, the Wednesday is actually 8 days almost. But if we now approach this as all time saved, so even we can have Sundays, holidays excluded terms, loading terms. So let's say loading terms is 2,000 tons per day, pro rata, Sundays, holidays excluded, all and then $10,000 demurrage half dispatch, all time saved. That actually means that once the lay time clock, once loading has completed, and we're still like we said in one of the first slides, the charter is entitled to that time because he paid for it, and let's say we still have 7 days left before the before lay time exceeds, or 10 days left before lay time exceeds, then in this case it means that even the excluded time, so the weekend, actually counts, since we've agreed to all time saved. So for the charterer, this makes quite a big difference. When we assume 4 days, 9 hours, plus 2 days and 15 hours, and in the case of working time saved, and we saved 7 days at $5,000 a day, dispatch. That's $35,000 dispatch. That's a discount you get from the ship owner. If you had agreed on all time saved, is a totally different. We almost gain 3 days, and see the difference and discount as well. $49,000, almost $50,000 opposed to $35,000. So all time saved is always better for the charterers. So now we discussed dispatch, and then what we should also discuss also some practical insights into demurrage. So we know now if we finish early, we might be entitled, if we agree to that, if the contract, the charter party allows, we might be entitled to dispatch. If, of course, on the other hand, we exceeded the allowed time, we've used not only the time that was allowed, but we extended it, we run over it by an hour, a minute, days, 10 days, 30 days, it happens. When does it start to run, that demurrage? Well, upon expiry of the lay time, if the ship is still loading or discharging, unless the charter party says otherwise. So usually you'll have, let's say 10 days all purposes. Once you exceed those 10 days, the next days you're into demurrage. Then what suspends the running of demurrage? I will see, just like in the case of lay time, either default of the ship owner, breakdown, or exception clauses in the party, in the charter party. We will see clauses, for instance, if we go back to the draft survey, it might say in the exception clauses, draft surveys not to count as lay time. That's very simple. Then we know it during lay time, and we have a draft survey, we will deduct that hour of draft survey. Now, it might also be that they just add a couple of words saying draft surveys not to count as lay time or time on demurrage. What this means is actually, even if the vessel is on demurrage, then draft survey will not count as lay time or time on demurrage. You need to deduct it from the demurrage. So there's this famous adagio where, once on demurrage, always on demurrage. Well, that's not always the case, and in most cases it's more theory than practice. So when does demurrage finally stop running? Well, traditionally when loading or discharging stops, but the charter party may specify differently on disconnection of hoses or when the cargo documents are on board. It's basically the same as for the lay time, but here it's applied on your demurrage. But in most cases, it will be when operation stops. So that's when demurrage also stops. So the charter party clauses which suspend the running of lay time do not suspend the running of demurrage, like we said with that with the draft survey, for instance. If it only says draft survey not to count as lay time, and you do 10 draft surveys once the vessel is already on demurrage, well, that's bad luck. They cannot be deducted. But if it says draft surveys not to count as lay time or time on demurrage, then that's differently. So the vessel, unless the charter party states differently, the vessel will remain on demurrage until either the loading or the discharging is completed or the charter party is frustrated. I won't dig too deep in that either, because it could be that it really takes long, something happens on the terminal, then the charter party might be frustrated. But basically, keep in mind, demurrage stops when operations stop. When is it payable? Now we saw in the example, if it's non-reversible, basically that means that, say we have a trip of 40 days, the vessel loaded 5 days, a trip. We have the ship owner assumed that you would use his vessel for 40 days. Now we loaded, let's say 2 days. That means, and we run up demurrage. Let's say we run up demurrage, we have 2 days demurrage for the 2 additional days. So that means that once the vessel sails from the loading port, the owner is entitled to draw up his demurrage bill, the invoice, and send the charter the invoice for the demurrage occurred in that port. Now we know, okay, the trip is going to take still 38 or 40 days. The vessel is sailing 40 days and arrives in the discharging port. If it had been reversible, this meant that the ship owner could not yet send his invoice because he doesn't know what will happen in the discharge port. He will have to wait until operations are completed there before he can actually drop his or finalize his demurrage bill, if any, or dispatch credit note, if that would be the case. So you see the distinction here. Here already, you paid the freight, and two days, or you paid 90% of the freight as a charter. Already 4 days into the operation, into the voyage, you will get a bill from the ship owner for the demurrage. And if it's let's say in a strong market, saying $45,000 a day, 2 days demurrage, here's your demurrage invoice, please pay $95,000. The same might happen, but here the owner has to wait then. And in this case, the owner gets his $95,000. He doesn't know what will happen in the discharge port, and it might be that there's a lot of dispatch. So he might, from that $95,000, it might be that he has to return half of it. We don't know. That's the non-reversible scenario. If it's the reversible scenario, this means once the vessel has sailed, even though the ship owner knows now and the charter know, okay, we've incurred 2 days of demurrage, we will have to wait until the entire voyage is completed, until discharging and the last discharging port is finished before the ship owner can drop his invoice. So obviously this reversible, again, we see as favorable to the charterers. Usually we'll find, and the charter party, we will see it will be closed, and it will say usually demurrage shall fall due day by day and shall be payable upon receipt of the owner's invoice. It's always it's calculated day by day, but it might not be applicable on a day by day basis. So, and like in voyage freight, the amount of demurrage negotiated often reflects the current market conditions. We will go a little deeper into this, maybe during the questions if you want to. And then there's also the matter of time bars. Like I said in the introduction, I had a case where we fixed, when I was still working as a shipbroker, we fixed 3 separate vessels for the same client for 3 similar voyages, and in 3 occasions we knew we run up demurrage quite significantly, and still we didn't get the time. We didn't get the demurrage bill. But on the other hand, so that means careful with time bars. It means specifically from the ship owner's point of view, some time bars are really short. Could be 24 hours. The charter party might stipulate that demurrage claims need to be presented together with all the relevant documents within 24 hours after discharging. It might be 2 days, it might be 10 days, whatever. Like we said, freedom of contract under English law, whatever you agree, might be 90 days. There is no set standard for it. You can agree on on what you want, but the thing is, then you need to live by it. And from the ship owner's point of view, it literally means, let's say you have a $95,000 demurrage bill, and there is a 2-day time bar. You've passed the time bar. Well, that's bad luck. But you're no longer entitled to send your and charters will reject your claim. The thing is, obviously, these things could and can happen with very short time bars, but usually the owners are quite aware of it, and they will send you a very rough demurrage bill to at least be within the time. But some, if you have even within 90 days, it does happen. And why does this happen? And in a lot of cases, you have to keep in mind some of with some ship owners, they have a limited staff, or they are short-staffed. They have a number of vessel operators, as they are called, people that are dealing with the specific vessels in the fleet. Sometimes you would have two persons dealing with 5 or 6 vessels. So you can imagine they have a lot on their plate, and it does happen sometimes that they miss a time bar. So that's not a fun thing. So, but we know now, when the merge starts to run, when a lay time is exceeded, what suspends the running of the merge? Basically nothing, because once on the merge, always on the merge, except when some events are excluded from time on the merge. And when does it finally stop running? When is it payable? And to be careful with time bars. Are there other remedies for the ship owner if you keep his vessel longer than expected? Yes. That brings us to detention. If the charter delays the vessel for a period of time that is not covered by the laytime provisions of the charter party, then the ship owner may still claim damages for detention. To give you an example, let's say that we've agreed that laytime stops when cargo operations are completed. So the cargo operations are completed, the vessel is waiting for the agent to come with the documents, and the agent doesn't come. Not in the next hour, not in the next 2 hours, 5 hours, half a day. I've seen a case where they had to wait 48 hours, the ship had to wait 48 hours for their documents. So then obviously you are detaining, unrightfully holding the vessel, and the charter is entitled, the owner is entitled to detention. So detention refers to when the ship is detained for reasons within the charter's sphere of responsibility. If the vessel remains at the berth because it has a technical malfunction, obviously that's not within the charter's sphere of responsibility. But if the vessel is detained at berth, or is still at berth because the charterers failed to bring the documents on board, and that's a difference. So it prevents the ship from leaving the port after completion of loading or discharging. So damages for detention are not negotiable and are unliquidated compared to demurrage, which are liquidated damages. Unlike demurrage, detention can be used as a contractual remedy when undefined lay time has been agreed upon. And demurrage, obviously, if we look at demurrage, is the compensation paid to the ship owners. The charters fail to load or discharge the vessel within the lay time allowed. So a totally different. So I think that's quite clear, the difference between demurrage and detention. And that brings us to an interesting case. I thought I bring this case, we're talking about demurrage, but what does it actually cover? So the precise scope of losses covered by demurrage, or the question is whether demurrage only covers the loss of earnings or money to the ship owner for the extended use of the vessel, or if it also covers other costs like damage to the cargo. And there's this very interesting case of eternal bliss. Perhaps you've already heard of it. In this case, the vessel, the voyage in question, involved the carriage of soybeans from Brazil to China. There was a Nord tender on arrival in China, but the vessel waited 31 days at anchorage due to port congestion and lack of storage space ashore for soybeans. So the cargo exhibited significant mold. It started to deteriorate, and receivers claimed against the owners. The cargo claim was settled. The owners paid through their insurance company, through their P&I company. They paid $1.1 million in damage, in claim and cargo damage. So the owners had been paid demurrage as a result of charter's failure to finish within time. So now what happens was that I won't go too much into detail, but what happens was that the owners P&I club tried to recover from the charters insurance, I assume, or from the charters, that cargo claim. And charters said, but we paid demurrage. We paid 31 days, let's say at $20,000, that's quite a significant amount, 600 and something thousand, close to, or a bit over $600,000. We paid. We haven't breached the contract. We paid, and this is the discussion which is now going on. So, what loss does demurrage really cover? Because if we extend that question, what happens if the ship owner has to get compensated for damages? They need to show that the charter did something wrong. That's one thing, but there was an additional breach of contract. The list of possible costs that can arise from a delay is potentially long. That there will not only be cargo claims, but if you wait 31 days or 31 days at anchorage, there might be hull fouling. So there might be the cost of hull fouling, unexpected port costs. It could be anything. Cost of needing to shift to bunker, supplies, cost of increased crew change, and so on. So you see, this brings quite an interesting question. I don't have the answer to it, to be honest. But the Supreme Court will soon decide in England what demurrage covers, so there won't be any more confusion about it. And whilst the eternal bliss is no doubt disappointing from the point of view of the time charters, other parties that voyage charter other vessels, it does clarify the reach of the common demurrage provisions, which will allow future voyage charter parties to be drafted in a way to reflect the parties' intentions. This basically means, imagine if a demurrage rate can or should cover all costs. Yeah, it's a tricky question, because usually it only covers the time lost by the charter. The charter compensates the owner for the time lost. Now, if we are pulling this open, then what happens then is the demurrage rate now as a reflection, like we said, of the market rate, or usually a reflection of the market rate will be the market rate and a premium perhaps, because the ship owner might anticipate a higher market or an increasing freight market. But how will you agree on a demurrage rate if you need to cover for all those costs? Well, it will no longer reflect the market rate, and it might make a contract almost unworkable. So this is, I think, the reward or the judgment is expected sometime, and I think in August or September of this year. I'll be quite interested to see how this will land. So that brings us to late time start. So we saw now, what sort of, we want to talk a little bit about late time start, because there's one of the most disputed topics in late time is when late time starts. You can run your calculation, and your calculation may be perfect in the terms that you've deducted all the exclusions you've allowed, and I can tell you sometimes in specific statement of facts, I've come across statement of facts that take 10 pages because it's continuously, operations are continuously interrupted by rain, by snow, by wind, and so on and so on. So it's quite important, that you deduct that. But if you, even though you've done that very rigorously, you've deducted all those interruptions, but you got your start time wrong, that renders your whole calculation invalid. So for the late time to start, we saw that it needs to start at the right place, in the right condition, and a valid NOR must be given. Here it's important that we make a distinction between a berth charter party and between a berth charter party and a port charter party. Traditionally, the ship has arrived at the berth if the charter is a berth charter party, or at the usual waiting area if the charter, if it's a port charter party, and if the berth is occupied. But if the if there is an allowance of the famous 4 Ws, whether in port or not, whether in berth, these all have the effect of advancing, bringing forward to an earlier date and time the commencement of lay time. So basically what it does mean, let's say you have a berth charter party, your vessel arrives, arrives at the port, let's say it arrives at the usual waiting place, let's say that's the pilot station, but it turns out that the berth is unavailable. Technically, I mean, from the contractually, if it's a berth charter party, this means the vessel or the master can only tender notice of readiness when the vessel is alongside, berthed, all fast. However, if that berth now seems occupied and unavailable, unreachable, this means that this whether in port or not, whether in berth or not, means literally that the master is now entitled to tender notice of readiness and say, hey, listen, I am here, my vessel is ready in all respects, but your berth is not available. So it's quite important to make the distinction between a berth charter party and a port charter party. If it's a port charter party, obviously, when the vessel arrives at the usual waiting place, the master can tender notice of readiness, send his email to all the parties at the right time, or Sundays, holidays included, any time, day and night, depending on the terms they've agreed on. They can tender the notice of readiness, and the lay time clock will start. Lay time will start. It's different, obviously, if it's a berth charter party. Lay time will only start when the vessel is at the berth, unless the berth is occupied. But without or before digging into deep, what I'll do is I'll show you a couple of steps, quick steps to determine the lay time start. So here in this case, we've got we see a vessel, the grain racer, the port is Odessa. What is the charter party type? Well, we found from the charter party, we found that it's a berth charter party. Is the berth available? Another question we need to ask. No, it's not available. When was the lay date? Laycan. It's the 7th of the 10th, and the cancellation date. Okay, not that important here, but still you will see that it makes a difference. So the vessel arrives on the 6th and tenders notice of readiness on the 7th. What do we see? The vessel arrived ahead of the laycan. See, the 6th on the 6th of October, while the lay date is only the 7th of October. Is it ahead of the laycan? Yes. Do you have to tender between office hours? Yes. Does time count? Time meaning time ahead of the laycan? No. So just a couple of steps to go through. Okay. So what's the next working day and time? Well, according to our charter party, the next working day and time is the 7th at 0800. Was the NOR validly tendered? Oh, it's validly tendered on the 7th of the 10th, or it's valid on the 7th at 8 o'clock in the morning. Did we agree on any turn time? Oh yes, we agreed on 12 hours turn time. This, the turn time is the time given. Usually it could be 6 hours or could be a day actually, but 12 hours is already quite generous, I think. Turn time usually is given to allow charters to prepare stevedores, or giving their orders, organizing teams, organizing the trains, perhaps, all sorts of things they need to set in motion. That's what the turn time means. So now the effect of the turn time means our notice of readiness is actually active 12 hours later. We've agreed on that. The NOR was valid at 0800, but by contract we're entitled to another 12 hours. So the NOR is only active at 2000 at 8 o'clock in the evening on the 7th of October. But did we sooner commence? When did operations commence? Ah, yes, we commenced sooner. At what time? Oh, we commenced at 1800. So basically, by commencing earlier, this is An acceptance of the notice of readiness. This renders the notice of readiness active. So basically, lay time now starts at 1800. You see, basically, it would have, the NOR would be active at 8 o'clock. We see here the vessel arrived actually on the 6th, and lay time only starts on the 7th at 1800. And then just for for fun, I've put in operations completed on the 9th, and the total time used. But this total time is only indicational. There are no deductions, but it gives you an idea of how much time that the vessel was in port in total. And then obviously there will be some deductions shifting to the berth. There might be draft surveys, there may be opening and closing hatches, might be all sorts of exclusions, as we saw. So now this is a way to look at how to define the lay time start. There's a number of questions, but we can also do, and we find all this data. I have to say, all this data we find in the statement of facts, definitely all the times, and then part obviously of it we find in the chartered party. If it's a berth chartered party, etc. We can also visualize this. We can also look at, if we, I would have to put on my glasses because not very clear. I hope it's a bit clearer for you. But basically, the top line is the estimated duration. What the ship owner has assumed to and based calculated his freight on, and then below we see what the actual time we used, and the actual time that will we'll see that the vessel we had the approach voyage, and then we will see but the time allowed was only up in the gray bar. We'll see that this was the time allowed, so we exceeded the time allowed. We also see when we tendered notice of readiness, etc. We also see when loading commenced and loading was completed. So then the vessel sailed, the carrying voyage, and so on. And then see the vessel arrived. But we see that there is quite an overshoot and time used to what the ship owner had anticipated. So obviously we need to compensate that. And like I said, it's just another way of visualizing what happens in the port or during a voyage, and why demurrage and dispatch are so important to the total result of the voyage. Another way to do it, and that this will bring us to the next topic, is to use low code. And I'll see if I can start this, because the next topic will be technology. So what happens here, it's the same steps. MV Grain Racer, Port of Odessa, is the berth available? Yes, it's available. These you can interchange all the questions. When did the vessel arrive? Was it ahead of laycan? Time to count. Very simple ways, very simple steps, but helping you basically, if you got this right, to you see the lay time start, you get this right, then the rest of your calculation will be correct as well. And that basically brings us to the topic of innovation. And quickly, so triggers for innovation, ESG, Sustainable Development Goals. Why am I talking about this? We have the environmental, there's a lot to do by environmental, social, and governance. So our new regulation, a trigger for innovation. And you will say, how did we all of a sudden land into innovation? Well, we'll see that there's a lot of solutions allowing you to calculate lay time, to process lay time. A lot of solutions giving you in-depth insight into lay time. Meaning, with the right tools, you will be able to see where do our vessels, or when we charter a vessel, where do we spend most of the time, or where do we run the most risk of delay, of demurrage. So quite important. And probably heard the Poseidon Principles and the Sea Cargo Charter. You can go through that and read it once you've downloaded the document. I won't go too deep into it. But basically, the ESG will have a lot of effect on shipping, and by consequence, it will also have an effect on lay time, because the amount of time a vessel spends in port and the percentage of the voyage time in laden versus ballast state will impact its rating, and this may influence the freight rate and hence the demurrage rates. I won't go too much into detail. You can read it. There is a bit of a commotion around the CII, the carbon intensity indication, but I don't want to go too deep into that. I want to bore you with that. But to give you an idea, this is the maritime technology landscape, kindly provided by Sky Sales Advisors, and it shows us the amount of technology, increasing number of technology solutions throughout the entire chain. We'll see some will be on the commercial side, some will be on the vessel management side, on the operational side, also on the lay time, on the fixture and recap side, and it's growing. This map is regularly updated, and if you're interested in it, you can find it on Sky Sail Advisors. They update it every so often, I think every 3 or 4 months, every quarter, and it's quite interesting to follow. And this brings us to the next slide, actually, and what I say, okay, even though there is a lot of technology around, there is a lot of ways to manage our lay time and demurrage, to calculate everything. The human factor of skill and knowledge is still very essential, and this brings us to almost the end. It's a saying I often use, and unfortunately, it's a fact. A fool with a tool is still a fool. You may have the best solution, you may have the best software, the best technology, but if you don't know how to interpret the charter party, the statement of facts, the notice of readiness, if you don't know this, then it will be hard to implement, and it will be hard to come to a good calculation. But the good news is, the solution to that is obviously training, trying to tame the dinosaur. And training today, obviously, for success of tomorrow. And also in training, and this is the last slide, also in training, the landscape is changing. We see kids using TikTok to show each other how to bake muffins and stuff like that. People will show you how they, I don't know, maintain their garden using TikTok. There's upskilling, there's reskilling, and TikTok especially is micro learning. There's data-driven learning. What I'm very fond of is user-generated content, which is basically employees training their colleagues, or train the trainer programs and so. And then there's extended reality. You might think it's science fiction now, but it's coming definitely, where we use virtual reality to train things, to get ourselves familiar with to learn how can we process all that data from charter parties, from statement of facts, turn it into proper lay time calculation. And the final point I want to leave you with is exercise. If you have the time, you can run it on an A4. Determine, like we said, the allowable lay time, whether it's calculated or definite. Calculate the lay time that you have used, how much time was spent in port, and that will give you a result. That result multiplied by demurrage will show you the amount of demurrage due, or the amount of dispatch due from the ship owner side, and exercise with it, play with it, like I've done and I still do every day, but then for ship owners and charters and traders and so on. And basically, my friends, this brings us to the end, and I would like to thank you for your attention, and I hope you enjoyed it, and if you have any question.
We really did. Jean-Paul, thank you very much. Very profound.
I hope I didn't take up too much time though.
No, it's okay. It's okay. We are just in time. So I told you that we are flexible. Yeah, very good dive. Yeah, I really enjoyed it. Yeah.
Oh, thank you.
We got questions. That means that you were straight to the point.
Okay.
The first question is, let's come back to when should be demurrage payable upon receipt. What does it mean? It doesn't mean immediately. And can you comment what's the norm regulating?
There is, of course, there is a difference between, let's say, the what we call the spirit of the contract and the legal side of it, the strict side of the contract. In most cases, what I see, I mean, from a practical viewpoint, what I see is that owners, even though they are entitled to make an invoice or a claim for demurrage at the first load port, usually they wait and present those bills together with the final freight invoice. That's usually the most common practice that I see. But you know, by the letter of the law, if you would follow the letter, that means that the owner would be entitled, once, you know, under a non-reversible regime, would be entitled, you know, once the vessel leaves the port, to prepare his demurrage invoice and send it to. And I think we discussed that. The thing is, of course, if this is a really lengthy voyage, if the vessel still has to sail 40 days, for instance, from Brazil or Southern America to China, that also means that the owner has to wait, you know, a substantial time before he can draw up his invoice. But it's usually done together with the final freight invoice.
Thank you. Next question. What is best pro forma? So you were a shipbroker. Now you run the demurrage desk. Yes. What is best pro forma charter party?
You mean the
typical?
best?
I would say it's a typical question that from time
the best
to
type
time
of contract.
we
Is that what you? Is that the question? I think the question is, what is the best type of contract?
Yeah,
towards
correct. Pro forma, standard pro forma. It's a typical question that we receive from clients.
I think Richard very clearly pointed out freedom of contract. You will find, you know, there's lots of contracts and contract types, and all they do is provide a framework. They are a framework, but you are free to add riders to that contract and to add clauses to that contract, to agree to different terms, to strike out a whole, you know, if you don't agree or you don't like you use BIMCO, GenCon, you don't like the way they treat lay time, you have your own approach to it, and because you're comfortable with that, and the owners you've been dealing with are comfortable, you're entitled to strike that out and to write a separate clause. There, all those contracts, you have to keep in mind, whether it's ASBA Tangvoy or if it's Norgrain or GenCon, they provide a really, and especially now GenCon 2022 provides a very rigid, a very workable document. But the problem is, and that's the thing with standard contracts, it will not always answer everybody's or every specific owner or charter's needs. So the way to compensate that, charters, or I see that Richard has a question, will agree, and those whatever they agree outside that framework, they will put in a rider. Yes, Richard.
Yeah, Richard.
I was just going to make a comment of the question is, what is the best pro forma? There is no answer to that. No, as Jean-Paul is saying, the Aspatank, Norgrain, these are house charter parties. But also what Jean-Paul is saying, and what I would happily repeat, is you start with the agreement between the parties. That's your first contract. Where there are gaps in that party, if you're on an iron ore contract or something, then you go to a house charter party for iron ore to fill in the gaps. If there are gaps or disputes still arising after that, then you end up in arbitration and we apply English law. So you have, first of all, the freedom of contract to agree between the parties, backed up by the pro forma, whichever one you choose. If you can't get an answer out of that, you end up before me as an arbitrator or the High Court, who will apply the law. So there are 3-4 layers to that contract.
Yeah.
That's the only comment.
No, exactly. There's nothing more I could add. Like, I don't think there is one sanctifying contract that will save you from whatever you want, whatever it is that you want saving from. But you will always be confronted with the terms, and like Richard said, with the terms and the conditions that which translate your intention, what you wanted to do, are poured into the contract, and basically that is. So to answer in short, there is no one specific perfect pro forma. There will always be gaps, and those gaps may be very specifically related to the trade you are in. If you're in timber trade, it will be totally different than if you are you will have different requirements than if you are in grain trade. Yeah. I hope that answers the question.
Yes, Alexei. Okay, we have some questions in the chat. Dear Jean-Paul, if the loading operations are finished and documents are tendered, but by some technical issues, vessel cannot depart from the port of loading, is a ship owner entitled to apply detention fee towards to the charter party?
No. That's a good question. Basically, like we said, the detention need to be within the charterer's sphere. If it's within the charterer's control, if it's something as a result of the charterer's wrongdoing sounds a bit heavy, but in the charterer's fault, let's say the charters fail to bring documents on board. Okay, if it's a technical malfunction on the vessel, then it's the ship owner's default, and the ship owner, in my opinion, would not be able to, or not be entitled to claim detention. If, on the other hand, imagine the vessel is there, the documents are on board, and a shore crane collapses on deck of the vessel. Yeah. The vessel is detained; it cannot sail. But I would think that this is within the charterer's sphere. So it's a technical issue, but that's within the charterer's sphere of, okay, obviously that's the charter, that's not, the charter is not to blame for an event of that, but the owner will be entitled to claim detention. You detained his vessel because your infrastructure, or the infrastructure you use, the stevedore you appointed, being an agent of the charterer, is responsible for its equipment, and its equipment is now on your deck and preventing you from sailing.
Thank you very much. The next one. If the vessel arrives at load port and tenders north, but the cargo is not ready and available at that moment, does time lost for waiting of cargo considers as detention, or laycan is counting and demurrage applies?
Okay, so vessel arrives at the
and tenders north, but the cargo
notice of readiness. Yep. Tender's notice of readiness. If it's validly tendered, that means that the lay time will start to count. If that cargo is not available, yeah, that's bad luck for the charterer. But the lay time clock will continue to run. Yeah, I think it's a very straightforward answer, I think.
Yeah. can reversible or overage lay time be used in if there is a pre-dispatch as per charter party?
No, then it doesn't make sense. If it's free dispatch, that means even though, imagine that you've agreed on in our example, you've agreed on $20,000 per day per rata demurrage free dispatch. That means you're entitled to zero. So what happens then, even though you saved, for instance, 2-3 days, I do come across in bulk trades and free dispatch, but not very often. It's more in short sea trades, but it does happen. And then basically what it means is that, but then if I would be the charterer and the owner wants to impose free dispatch, I would definitely try to get an advantage or a better freight rate than, or to my advantage, because now I know if I save the owner time, I'm not entitled to any discount. But then again, you have to keep in mind, dispatch is something that the ship owner grants the charter. This is a situation where the ship owner say, listen, the ship owner is not obliged to do that. They don't have to give you dispatch. They only agree to dispatch. If the ship owner says, listen, if you can finish my vessel earlier than anticipated within the allowed lay time, okay, then I will allow for you under the regime of demurrage and dispatch, by half dispatch, I will allow you a sort of a discount, a benefit. But it doesn't have to do that. And obviously, when it's free dispatched, even if you save 10 days, you're at $40,000, which would be 40,000 times 10, 400,000, half the merge, $200,000, you're entitled to nothing because it's free dispatch.
Thank you. We have also one more question. This is like some kind of general question about the detention during the transit or during the passing of the channels, for example, on Danube. But Jean-Paul, let's design the situation, the lower standard, and the vessel shall proceed through the channel to the port of loading. For example, it's a Danube river, port of Ismail. And
okay,
through the channel now it's some kind of bottleneck and a big traffic, etc. And that's why the vessel have a detention there.
Yeah.
So,
okay.
So what is this? What will be the further step in this situation?
Okay. Well, there are two possible. I think there are two possible scenarios here. If it's a port charter, or let's say if it's a berth charter party, and the berth is available, then the vessel, should proceed to the berth, and at the berth it will be able to give notice of readiness. If this is now, if the process of going through that channel is delayed, that's on the owner's risk and time. If, of course, this is a berth charter party where it says, whether in berth or not, that also, and assuming that, let's say that or a port charter, if it's a port charter party, then the vessel is allowed to tender notice of readiness at the usual waiting place, and this usual waiting place can be outside this river, like you say, outside Danube River. Then, of course, the lay time clock starts to run, but in most cases we will find that is part of shifting, and shifting is always excluded. Shifting from, let's say, the usual waiting place where they take on the pilot to the berth will be excluded. And I've seen cases, for instance, I think it's for the port of Trombetas, where sometimes the usual place is defined as the name of the port or the place is escaping me for the moment, but it actually takes 2 days. Paranau? No, it's not Paranau. It takes 2 days to sail to the actual port. So that means if you're allowed to tender notice of readiness Okay, lay time will start to count, the time you are waiting at the anchorage, but the moment the pilot boards and proceeds, or the anchor, depending on the contract, or you heave anchor and the vessel proceeds to its berth, that time, and it could be significant, and like for instance with the river Danube, it will be the same if there's bottlenecks or something, that time usually is excluded. Unless you are ready, unless lay time only starts counting, or unless you're ready on the merge, and even then it's a tricky one.
Thank you very much. Another question. Can you please tell where that term dispatch appears in the official document?
Where dispatch appears?
Yeah.
Okay.
The term dispatch appears in the official document. Where we can find it?
We will find it in the charter party or in the recap, or where whatever you've agreed on. Let's say you were on WhatsApp with your ship owner, and your ship owner says, Arthur, I want to I'll give you my vessel, and this is the freight rate, and I want $20,000 per day demurrage. This is the demurrage rate, half dispatch, HD, half dispatch, and that's usually where you will find it. And there will also be specific clause in the charter party, obviously, or in the recap, or wherever you, but definitely in your charter party or in your rider, there will be a specific clause saying, listen, this is what we've agreed on, the demurrage rate, whether there is free dispatch, whether it's half dispatch, and this is the rate that we've agreed upon. You will find this in your and not only in the rider. For instance, if using BIMCO, I know it will also be in the box, they call it the box form, the first page where you have all the parties, the shipper, the receiver, the ship owner, the type of cargo, the amount to be carried, and so on. You will also find the merge rate, and even there it will also say whether it's half dispatch or free dispatch.
Thank you, Jean-Paul. We are over with questions.
Okay.
So it's time.
Well, Richard has
Richard, please.
Richard has another question.
Not a question. The last question came up was, where can you find official dispatch? Yes, it's mentioned in charter parties, but I think the question is more likely to be somebody looking for information about dispatch.
The market rates, yeah.
Yeah, and I would only suggest that there's a very good reference book, Scruton on charter parties. There are many reference books. Scruton is perhaps the Bible, and I would suggest that that whoever put that question go to a reference book like Scruton, a Bible, and look at how dispatch is described in a classic reference book such as Scruton on charter parties. That's the only comment I was going to make.
If it's on, maybe I want to add something to that. Of course, if that's the question, if you want to find information on the demurrage rates, basically what I would do as a trader or a broker or anybody who was interested in that is look at the market. Look at what the market is doing at a specific trade. If the market is low, I can assure you the demurrage rate will reflect that market, because traders are also not ignorant of what's happening in the market. They know what's happening. They will know the market rates more or less. They will know what fixtures have been done, and they will also know, just like an owner makes voyage estimates, the savvy trader will also make voyage estimates, and they will also know, what at a specific time or a specific date, what the market rate is. Now, if a ship owner would present an excessive demurrage rate that does not reflect, which is a lot higher than the market, obviously that would trigger questions, and some explanation would have to be given there. But usually what happens is that the ship owner looks, he calculates the use of his vessel on the duration and on the market rate, and to to compensate for any excessive time that you use, excess time that you use his vessel. He will look at what would my vessel be able to earn in the market, and the only way for the ship owner to do that is to look at what is the market at the moment, what is the market today, but I don't know what the market will be in 40 days and 60 days. So the way to compensate or to absorb that more or less is to take today's and I'll give you an example in a moment. I'll go a bit deeper on this and then I'll stop. But the way that a ship owner anticipates this is to take today's current market rate, being the hire per day that his vessel could earn, and adds a little premium, could be 10-20%. And what I meant by going into deeper, sometimes you will find that demurrage rates are referred to specific trades published by the Baltic Exchange, specific trades plus $2,000. So that means that it's index linked, that the demurrage is linked to the Baltic Exchange specific index for the trade route that you are using.
Can I just add something here? We're talking of traders and when traders charter ships, but in the sale contracts, you can also have demurrage rates.
Yeah.
The trader has to be very careful, and most traders I know or worked with are very careful. It is possible to have a demurrage rate in your sale contract and a slightly lower demurrage rate in the charter party contract. So what I'm saying is it is not illegal and it is not impossible for a trader to make a profit on demurrage.
Demurrage, yes, absolutely. Fully agree.
Thank you.
Okay. So for today we are over, I think so. That was a traditional course dedicated to English contract law, arranged by Interlegal together with the Black Sea Institute of Shipping and International Trade Law. We would like to say special thanks to our presenters today, to Richard Faint and Jean-Paul de Zutter. You were very profound, you were very deep, and we really enjoyed. I think that all the delegates also enjoyed your talks and presentations. All the presentations will be distributed, sent to all delegates after we finish the course. A few words about tomorrow. Tomorrow we have a second day. We start same time. There will be 3 presentations from leading lawyers of Interlegal. One dedicated to cases with the view from a shipowner side. They run by Mykola Kazachenko.
Yeah.
Then there will be a case study presented by Igor Kostov with the view from a commodity cargo side, and there will be also a presentation run by Karina Gorova dedicated to specifics in shipments by containers. So this is the program for tomorrow. Tomorrow we start 12 o'clock Ukrainian time. I think tomorrow presentations will be a little bit shorter, so we will not exceed more than 2 hours and a half. So it's for tomorrow, but for today, thank you very much. See you tomorrow. Ciao. Bye-bye.
Thank you.
Bye.